complicated and need a bit of research, or where they're matter specific, we'll look to try and anonymize and deal with in FAQs that we'll send out in the early part of next week. On the webinar today, we have Katie Harris, who is an associate in the employment group. Katie, hopefully you can see her. Katie joined the group earlier in the year, in June, so it's probably one of the first times that Katie's been in the office. And I have to say that Katie and I are both socially distanced in different rooms on different floors, which wasn't our intention, but there we go. So Katie's been spending the last 4 or 5 months getting to know many of you on the call, and we hope that she'll get to know many more of you in the weeks and years and months to come. We also have Kerry Williams, who you may have heard at the outset. Kerry is a member of our marketing team, and she will deal with any technical issues should they arise. And then she has the joyous task at the end of our webinar of picking up your questions and grilling Katie and I to make sure that you get the answers you deserve. And finally, there's me. My name is Barry Stanton, and I'm a partner and head of the employment group at Boyce Turner. I also have the great responsibility of pressing the on button to make sure that we go through the slides. So if that goes wrong, all I can say is it's entirely my fault. So there you have the couple of pictures. So I'm now going to pass over to Katie and ask Katie, can you tell us what is IR35, please?
Yeah, thanks very much, Barry. So hello, everyone. So what is IR35? So IR35 was introduced by the Income Tax Earning and Pensions Act in 2000. And it was introduced by the government to tackle what it perceived to be a form of tax avoidance through the rising use of personal service companies by consultants as a means to avoid paying income tax and national insurance payments. So a personal service company is essentially a company that is owned wholly or mainly by the consultant, and the consultant will use that as a vehicle through which to provide their services to their clients. So rather than the consultant contracting directly with the client, the contract will instead be between the client and the consultant's personal service company. Now, this has a number of advantages, the main one being financial. So what will typically happen is that any fees paid in respect of the consultant services will be paid by the client to the personal service company. And the consultant will typically be an employee of his personal services company and will pay himself a nominal salary, typically within income tax thresholds. And then the vast majority of his earnings will be derived through dividends. So obviously there are substantial tax advantages there to both the consultant, who will not have to pay income tax and national insurance, but also to the client, who will not have to pay employer national insurance payments, and also removes the risk of there being any potential employment relationship there for employment law purposes. So how does IR35 seek to tackle this? Well, the government decided, look, we want people who are essentially working as employees to be taxed as employees, regardless of the structure through which they are working. So I've got a slide, and I think, Barry, if you could bring that up for me. So this shows a typical labour supply chain through which individual consultants will supply their services to end users. And what we have here is we have an individual consultant at the bottom, and then you have his personal services company, or PSC, just above him. Now, in this example, the consultant has engaged with an agency, which is very common, to find him work with the end user client. So you can see that there's an agency in the chain here just above the personal services company. And then the agency has contracted with the end user client for the services of the consultant. Now, IR35 works by saying that you have to ignore the agency and the PSC in the middle of that chain. So you pretend that they don't exist. And what you have to do is you have to imagine that there is a contract directly between the end user client and the individual consultant. And the courts and tribunals will construct a hypothetical contract based on the circumstances of the relationship between the end user client and the individual. And we'll go on to talk about that in a bit more detail later on. But essentially what IR35 asks you to do is to look at that hypothetical contract and ask whether, were it not for the agency or the PSC, that individual consultant would be in employment with the end user. And if the answer to that question is yes, then there is deemed employment for the purposes of IR35. And then any fees that are paid to the consultant's PSC by, in this case, the agency, would have to be subject to deductions for tax and national insurance. Now, at the moment, under the existing IR35 regime in the private sector, the responsibility for accounting for that tax and national insurance and deciding whether or not there is deemed employment rests with the personal service company. So at the end of every year, the consultant, via his personal services company, will have to review the engagements that he's undertaken through the course of that year and essentially put his hand up to HMRC and say whether or not he thinks those have constituted deemed employment. And if they have, then he has to pay over that tax and national insurance on any of the fees he received for those services. So as you can imagine, there are not many consultants who were very keen to put their hands up and admit to having been in deemed employment, which is part of the reason for the changes to the IR35 regime. So when we're looking at deemed employment, there is a very specific employment status test that we have to apply. Barry, can you tell us a little bit more about what that employment status test is?
Yes, of course. So many of you will be familiar with a lot of the decisions and discussions that have been taking place around workers and the gig economy. And the test that one has to apply is very similar, if not identical, to that test. Sadly, there's not a single test, and employment tribunals have struggled for the last 40, 50, 60 years to come up with a test that works. But there are a number of factors that have to be taken into account. And one of those is the question, whether is there mutuality of obligation? Now, for a lawyer, mutuality of obligation means potentially two things. The first issue is whether there is sufficient mutuality in relations between the parties for there to be a contract. And HMRC, when it's looking at its CESS tool, and we'll talk about the CESS tool later, assumes that there is mutuality of obligation because there's a contract. But in this context, what we're talking about is the, and I'll call them the employee, is the contractor obliged to turn up for work? And if the contractor does turn up for work, is the end user obliged to pay, even if there is no work? So that would be, if that is the case, then there's mutuality. But if there's no obligation to offer work, or if the contractor turns up, there's no obligation to give them work, then there would be no mutuality. And very often what we find is a relationship in these contracts where it's been going on for a long time, and the contractor keeps turning up and keeps doing work, and they become part and parcel of the organization. So you can begin to get mutuality. But it's very important when in looking at the contract, try and make sure that there is no mutuality of obligation within the contract. The next issue that one looks at is the question of control. Because again, for an employee, being controlled by the employer and being told what to do and how to do it is a very important part of what we used to call the master-servant relationship. So does the client have the right to control the way in which the work is done? Now, in this context, control isn't necessarily a very good test, because often what will have happened is that the end user would have gone to the consultant to provide specialist services that they don't have the skill set to do themselves. So control may be limited, or more limited in this context than it might be in an employment context, in a pure employment context. But again, it's important to see, is the contractor required to work between certain hours? Do they have to do certain things? Are they obliged to follow certain instructions? All of that comes within the context of control. a really big issue is the question of whether there's an ability to substitute. So is the consultant required to do the work personally, or can they send somebody else to do it? Because in the employees have to provide personal services, but consultants can generally send whoever they want to do the work. Now, very often what one sees in a contract is an ability to substitute, but that may have certain restrictions upon it. So the consultant may be required to do the work unless they're ill. And the more restrictions you place upon the ability to substitute, so that if you limit the class of people who can be allowed to substitute, or the circumstances in which they can be allowed to substitute, that limits the ability to substitute. And therefore, the argument that there isn't a completely unrestricted right to substitute and send whoever you want to do the work becomes much more difficult to make out. Being in business on your own account is, again, a very important element to the test and the factors to be taken into account. If you have a consultant who works solely for one company throughout the year and does no other work, they're not really in business on their own account. So being in business on your own account really means you have to look at, well, how many customers does this contractor have? Do they spend any money advertising or marketing their business? And if they're spending £100 a year marketing it, that's not really marketing the business. Do they carry any financial risk? If they make a mistake, do they have to put it right? Because normally you would expect a contractor, if they don't do a job properly, to be called back and they have to put it right at their own cost and expense in their own time. They don't get paid again for it. So there are all these factors, and there are lots of others, and I've mentioned them. Risk, how do they correct the work, have to be taken into account. But it's really when you look at all these issues and then you take a step back and you look at the overall picture, and the question is, does this feel more like a contract of employment than a contract in which the individual can decide what they do and how they do it? So they're really a proper contractor. And that is the test that has to be applied. And it's quite a difficult one. And Katie, you and I were talking about it the other day. And you say, well, it's almost, you look at it and then you're almost sticking your finger up and putting it in the air and saying, well, which way is the wind blowing today? It's not quite that simplistic, but it can be very difficult to work out what the answer is, because there won't be a very clear answer, because people will become part and parcel of the organization, which is, again, one of the factors that people look at. Does this person give instructions? Do they have management responsibility? All of those are relevant factors to be taken into account. So we're going to look now at how the test has been applied in a couple of the leading cases. And Katie, do you want to talk us through the Canal Street Productions case?
Yes, of course. So I think, as Barry's just alluded to, there are a number of different factors which are all taken into account for determining whether or not there's an employment status. And one of the things we'll see, I think, as we go through these cases is that each case really does turn on its own facts. And the different elements of the employment status test will have different importance and varying levels of importance depending on facts of that case. So the Canal Street Productions case is actually a fairly recent decision. So it's a 2019 decision. And it's one of a number of hearings in front of the First Tier Tax Tribunal relating to television presenters. In this case, this particular contract concerned a lady called Ms. Fospero, who was a television presenter who provided her services to her clients through her personal services company, Canal Street Productions. And the contract in question was a contract with ITV, which took place between 2012 and 2014. So it was a relatively short contract in terms of its duration. And the contract was for Ms. Fospero to provide her services by appearing on ITV's programmes Daybreak and Lorraine. So when looking at this case, and this is an interesting one because it's a case that HMRC actually lost here, and as we're going to see, they do tend to lose quite a few. And so the tribunal found that Ms. Fospero was actually outside of IR35. And these are the things that they considered when reaching that decision. So the first thing they looked at is personal service, and it was accepted by all parties in this case that Ms. Fospero was required to provide her services to ITV personally. There was no right of substitution. So the personal service element of the employment status test was satisfied. So the next question for the tribunal was there mutuality of obligation? Now, this case was particularly interesting because the tribunal had to consider mutuality of obligation in the context of there being a series of short-term assignments. So in Ms. Fospero's case, each assignment was actually quite short and could be as little as a few hours. But there were gaps in between her work for ITV that were fairly lengthy. And it was acknowledged that actually in those gaps, there was no obligation or expectation on ITV to actually provide any work for Ms. Fospero or even any future work for Ms. Fospero. And likewise, Ms. Fospero had no obligation to undertake any work if given to her by ITV. She could go and work for whoever she wanted, and in fact often did. Now, although contractually ITV had a right to Ms. Fospero's services on a first call basis, the tribunal found that the reality was that if ITV wanted Ms. Fospero to work in between assignments and Ms. Fospero was conflicted because of work she was already undertaking for another client, then Ms. Fospero would in practice just turn ITV down. So there was a clear finding there wasn't mutuality of obligation in between assignments. However, the tribunal did find that certainly in relation to each individual assignment, once Ms. Fospero had been offered work and had accepted it, there was then an obligation on Ms. Fospero to undertake that work and for ITV to pay her for it. So in relation to the individual assignments, the tribunal was satisfied that that was sufficient mutuality of obligation to satisfy that element of the employment status test. So the tribunal then went on to look at the question of control, and it decided in this case that there was a fairly significant amount of control by ITV over Ms. Fospero. In particular, ITV would retain control over the time and location at which the services would be performed, and they would also retain a quite exclusive editorial control over the programming. ITV also had the contractual right to direct Ms. Fospero and to sanction her if her performance was inadequate. So the tribunal also found that there was a sufficient degree of control over Ms. Fospero to also satisfy the control element of the test. So interestingly, we have a situation where we have personal service, sufficient mutuality of obligation, and also sufficient control to meet the employment status test. However, it was the other factors that were determinative in this case. And so the other factors that the tribunal took into account, and interestingly, the first of these was that lack of mutuality of obligation in between the individual assignments. The tribunal acknowledged that because both parties were free to do as they pleased in between assignments, and there was no expectation of future work, it gave rise to a degree of independence which was incompatible with employment status. In addition, the tribunal also found that there was evidence that Ms. Fospero was in business on her own account. Her agreement with ITV was just part of a wider business that she was undertaking through Castle Street Productions, and indeed she had many other clients. And although it was acknowledged that between 2012 and 2014, ITV was her main client, the tribunal found that there was evidence that during that time, Ms. Sparrow's agency had actually been actively looking for other assignments for Ms. Sparrow. And so the tribunal likened this relationship to one of a small business being reliant on a much larger client, and felt that this fact in itself wasn't inconsistent with Ms. Sparrow being self-employed. Finally, the tribunal held that there was evidence that Ms. Sparrow was acting in business on her own account because she had also incurred costs and expenses in running her business, for instance, agency fees and also the cost of equipment, such as the use of the cost of her earpiece and her laptop. And not only that, but because there was no expectation of future work, because Ms. Sparrow incurred these costs, there was a financial risk to her there. So there was this concept of financial risk and reward. And so the tribunal took into account these other factors and stood back and looked at the overall picture and felt that these other factors were significant enough to suggest that the contract was more akin with that of self-employment rather than employment. So that's a really interesting example of how important sometimes those other factors can be. And, you know, an example of how a case can turn on its own facts. And indeed, I think, Barry, if you can talk us through now a case where the tribunal came to a completely different outcome in relation to the same consultant and the same set of services.
Yes, Mr. Mantides. Well, Mr. Mantides was a locum urologist, and he worked locally at the Royal Berkshire Hospital and also at the Medway Maritime Hospital on 2 successive 3-month contracts. And this case really does show the importance of ensuring that you get the documentation right. At the Royal Berkshire Hospital, there wasn't really a written contract. There were some locum terms floating around, but there was no written contract for him. But at both hospitals, he saw patients, he reviewed x-rays, he used the hospital facilities and carried out various urological procedures. So he was doing the same job. But at the Royal Berkshire Hospital, there was no written contract. There was no provision for him to send a substitute. And they inferred from the documents that they could see that he was required and the hospital was required to find him between 30 and 40 hours of work a week. And they also inferred from the documentation that they could see that he was employed on 1 week's notice. Now, the Medway Maritime Hospital, the situation was very different. They had a written contract and it had a valid substitution clause. It also provided that there was no obligation to offer Mr. Mantides any work whatsoever if they didn't have patients who needed to be looked after. And the notice provision in the contract was 1 day. Now, as many of you will know, the minimum statutory notice period for an employee is 1 week. So 1 day's notice is very different to 1 week. So on this case, they found that the hypothetical contract they created for the Royal Berkshire Hospital was inside IR35, and he had his service company had to deduct tax and national insurance contributions. But for the contract with the Medway Maritime Hospital, that was outside IR35. So really important to make sure the documentation is right and creates the right picture. But having said that, there's no point in creating a document and a contract that doesn't reflect reality, because the tribunals will always look to the reality of the situation, no matter what the written contract says. So the contract has to reflect the reality. And as long as you can do that, you can create a situation which possibly could have been inside IR35, but can be taken outside IR35. Now, Katie, you're going to talk about the next case involving Krista Ackroyd, which made a lot of headlines.
Yes, it did. So again, this is another television presenter case, although in this case, actually, Krista Ackroyd was a television journalist for the BBC. And in contrast to the Castle Street Productions case, HMRC actually won this one. So the finding was that Krista Ackroyd was acting inside of IR35. So the contract in question here was a contract between the BBC and Krista Ackroyd's personal service company, Krista Ackroyd Media Limited. for the provision of Krista's services between 2006 and 2013. So it was a very lengthy contract of 7 years. And similar to the Castle Street Productions case, both parties accepted that there was personal service here. Again, there was no provision for Krista to provide a substitute. She was required to provide her services personally. So that element of the employment status test was satisfied. Looking then at mutuality of obligation, the tribunal found here that under the contract with the BBC, which also reflected the reality of the situation and how the contract had been carried out in practice, Krista was obliged to make herself available for up to 225 days per year. And in exchange for that, the BBC would pay her an annual fee, which it paid in monthly instalments. She was also entitled to a performance-related fee, which was linked to the commercial ratings of BBC's programmes throughout the duration of the contract. So that looked and smelt very much like a salary type arrangement. And the tribunal had no difficulty on those facts to find that there was clearly a mutuality of obligation there. There was an obligation on Miss Ackroyd to make herself available, provide her services for up to 225 days per year when the BBC wanted her to. And in return, there was also an obligation on the BBC to pay her an annual fee. So the tribunal then looked at the issue of control, and very similar to the Castle Street Productions case, it found again that the BBC had a significant degree of control over Miss Ackroyd. In particular, in this case, although she didn't have a line manager, she was subject to their appraisal process. And the BBC were entitled under the contract to direct what she did and how she did it. And in fact, it was found that she was subject to the BBC editorial guidelines. So the tribunal was satisfied that there was a significant degree of control in this case, which was akin to an employment relationship. They then looked at the other factors, and there was no evidence to suggest that Miss Ackroyd was in business on her own account. Although she had paid for some of her own equipment, this was on a very small scale and wasn't sufficient to satisfy this test or concept of there being financial risk and reward. Because Miss Ackroyd was in receipt of this annual salary, and she, there really was very little risk to her in the provision of these services. So the tribunal, looking back at the overall picture, had no difficulty in finding in this case that there was an employment relationship. And I think this case is a really interesting illustration of how different factors carry different weight in different circumstances. And in this case, the tribunal were particularly persuaded by the length of the contract that Miss Ackroyd had with the BBC and the degree of control that the BBC had over her. And it was really those two factors that led to the finding that Miss Ackroyd was operating inside of IR35. So, Barry, could you talk about another case, I think, where the finding was inside IR35?
Yes, the Northern Lights Solutions. Well, here, Mr. Lee had set up his own personal services company, Northern Lights Solutions, in about 2007. And for something like 12 years, worked as a project manager for the Nationwide Building Society. And bar a few short breaks, that was his own one and only client. And he worked for them on a series of fixed-term contracts. And in looking at the situation when it came before the first-tier tax tribunals, they said, well, there was mutuality of obligation because he was required to go to work and they were required to pay him. He was part of the management team, so he was giving tasks to employees and subcontractors retained by the Nationwide. He was responsible for dealing with costs and timescale of projects. He was very much integrated into the Nationwide team. He took little financial risk, and although there was a right to substitute in the contract, because everyone had told them that if you put that in, it helps, they recognized that it was very difficult for that right of substitution to be exercised in practice. And for all of those reasons, they found that Northern Lights Solutions was within IR35, and therefore it was liable for not having deducted the right amount of tax. Now, in this case, the tax was £70,000 that had to be paid. And in the Krista Ackroyd case, the tax that had to be paid was in the order of £400,000, as I recall. So you can see that when these contracts are over a long period of time, the cost of getting it wrong can be very significant indeed. So we talked, Katie, you talked at the beginning about there being historic issues, and that's really why the government and the revenue are now seeking to change what's going on, because the tests are difficult to apply. They've always been looking at a single person. So even if they win, it's only one taxpayer they win against, and they have to go and find lots of others. And the problem that HMRC have had is that they frequently lost. And we've seen a couple of cases where they've been successful, Krista Ackroyd and Northern Lights Solutions. But you may all have heard of the Lorraine Kelly case as well, where HMRC lost because Lorraine Kelly's defense was, well, this bubbly persona that you see every day on breakfast TV, well, that's not me, that's my persona, and it's a performance, so I shouldn't be responsible for paying tax. And she won her argument. And sadly Eamon Holmes lost his argument. So again, you can see that they're doing very similar jobs, but different answers. So what are the changes that are coming in? Well, we're looking only at the private sector because the public sector have moved a couple of years ago. And what it's going to do, the changes are going to come in from the 6th of April 2021, and they will apply to companies which are not small. And you're a small company if you have a turnover of less than 10.1 million, gross assets of less than 5.1 million, and fewer than 50 employees. But it doesn't just look at a single company, it looks at groups. So if you're in a group, you look at the size of the group, the turnover of the group, the gross assets of the group, so that even if you're a small company within a larger group, you may still be caught by these changes. And what do these changes do? Well, for medium and large companies, the medium and large companies will be required to determine the deemed employment of their contractors and deduct tax or pass the obligation to deduct tax to the fee payer or the end user. So if I can take you on to this example of a supply chain, it's very similar to the one Katie looked at. Here we have an end user, and it's engaged the contractor through a PSC, where it says fee payer. Well, that's really another agency. And then a second agency is engaged with the end user. And the obligation is going to be to deduct tax at the fee payer level, not at the PSC. So it's moved one step back. Now, the fee payer can also be the end user. They can be one and the same, but it depends how long the supply chain is. So you could have very elongated supply chains, and you could have much shorter supply chains. And that's important. So Katie, you're going to talk about what the implications are from what we call a status determination statement.
Yes, absolutely. So as Barry was just explaining, the key difference that's being brought in by the new rules is the change in the obligation for deciding whether or not there is deemed employment, and also for accounting for tax. That has moved away from the consultant's PSC and now rests with the end client, who has the responsibility for determining if there is deemed employment, and to the fee payer, which is the organisation responsible for paying the consultant's PSC to deduct the tax and national insurance. And how the new rules do this is they say that the client has an obligation to make what's called a status determination statement. Now, this does exactly what it says on the tin. essentially the client has to make a decision, and it has to do this before the consultant starts any work on the assignment. So right at the beginning of each assignment, the client has to determine whether or not that engagement is going to fall within IR35. So does that engagement meet the test for deemed employment that we've just been speaking about? And the client has to provide a written statement to the consultant, but also to the next entity in the chain, which is likely to be an agency if there is an agency in the middle, setting out what its decision is, the reasons for that decision, and it also has to take reasonable care in reaching that decision. And that written statement is what we call an SDS. And the SDS will only be valid if it meets all three of those components. So in other words, it's in writing, it sets out reasons for the decision, and it has been taken with reasonable care. Now, if the SDS is not a valid SDS, so it doesn't satisfy those three conditions, or if the end client fails to undertake the SDS at all, or fails to pass it down to the next entity in the chain or to the consultant, then it means that liability for accounting for any tax and national insurance will stay with the end client. So it will no longer be the fee payer's responsibility, it will be the end client's responsibility to account for that tax. So Barry, I think there's a slide that we can look at here, thank you. So just to illustrate how this operates, we've got, again, a similar slide that we've seen before, illustrating a typical labour supply chain. So we have the end user client at one end and the consultant and their PSC at the other. And here we have two agencies in the middle. So before the beginning of the assignment, the end user has to provide that written status determination statement to the consultant and also to the next agency in the supply chain. Now that agency in the supply chain also has to pass the SDS on down to the next entity in the supply chain, which in this case is the second agency or the fee payer, as they are responsible for paying the fees to the consultant's PSC. If, for example, the end user doesn't pass that SDS to the first agency in the chain there, then the liability for tax and national insurance payments will stay with the end user. Similarly, if the end user passes that SDS on to the agency, but that first agency doesn't pass it on to the fee payer, then it is the first agency who will have the responsibility for accounting for tax and national insurance payments. So in this way, the SDS is something of a hot potato. It has to be passed on to avoid getting burned, essentially. If you don't pass it on, liability for tax and national insurance will stay with you. So I think if we can move on to the next slide, Barry, so we can talk about what reasonable care means. So obviously, in order to move that liability on with your SDS, it's not enough just to pass that SDS on. As I've already mentioned, it has to satisfy certain criteria. One of those three criteria is that it has to be undertaken with reasonable care. So what does reasonable care mean? What does it look like? So HMRC has helpfully given us a little bit of guidance on this. And essentially, HMRC says that what is reasonable, it has to be viewed in the light of each particular client's resources, experience and circumstances. So it will expect a much higher degree of care to be taken by a large multinational company than it will by a much smaller company. But essentially, what HMRC will expect is it will expect to accurately apply the deemed employment test. So this will mean undertaking an information gathering exercise, making sure that the client is obtaining all of the information it needs to apply that test correctly, such as looking at the employment contracts, the way in which the contract is being performed in practice, and also understanding a little bit about how that consultant actually runs his business. Do they have other clients, for instance? Do they take financial risk? And ensuring that you keep adequate records of that information and the reasons for reaching the decision and the conclusion that you did. Using the HMRC CESS tool. So some of you may have heard of this. HMRC has introduced an online tool to assist clients with making an SDS. So this is known as the Check Employment Status Tool, or CESS, which I think Barry will talk about in a bit more later on. But that CESS is only as good as the information that is put into it. So again, it's ensuring that accurate information is put into that CESS tool. Making sure that the individuals within the client's organisation who will be undertaking the SDSs have sufficient knowledge and understanding and experience of that deemed employment status test so that they can apply it properly. And if they don't, if the client doesn't have individuals within its organisation that has that level of experience and knowledge, then it should be seeking professional advice and assistance. The SDS is not a one-off process. You don't just do an SDS at the beginning of the contract and think, great, that's it, the SDS is done. The way in which contracts are performed can change throughout the period of an assignment. And where anything changes in the relationship or the way the services are performed, there is an obligation on the client to review the SDS and make sure that it is still valid and up to date. So a failure to have a review process in place to do that will also be considered a lack of reasonable care. Some clients may look to subcontract out the undertaking of the SDS to a third party. For instance, many clients will ask their agency to do the SDS for them. That's absolutely fine, but HMRC makes it very clear that the responsibility for that SDS is still the client's. The client has to take reasonable steps to make sure that that SDS has been undertaken properly and carefully by the third party. HMRC has also given examples of the type of behaviour that would not be considered reasonable. And the main one of these is that clients should not be making blanket decisions. Now, this was brought in to address some of the issues that have arisen in the rollout to the public sector, where clients were taking a very cautious approach and basically just deciding that all of the consultants would be inside IR35. This was a particularly attractive option if it was an agency that was responsible for deducting tax and not the client. So the requirements of reasonable care have been brought in primarily to address that problem. And so it would not be reasonable care to just treat all consultants the same. Each engagement and each relationship with the consultant has to be looked at on a case-by-case basis. The absence of proper training and support to those undertaking SDSs would also be a failure of reasonable care. So, reasonable care is really a common sense approach, but just making sure that everyone has the right knowledge and training to do SDSs, that you have the right processes in place to make sure they're undertaken properly and reviewed correctly. And if using third parties, make sure that you have safeguards in place to make sure that they are doing those properly. So I think I have, is there another slide, Barry, coming up? No, right, sorry. So this is the client-led disagreement process. So what happens if a consultant disagrees with an SDS? So the new rules have also addressed this situation. Again, this is one of the issues originally with where the public sector processes, namely that there wasn't a route of redress for a consultant if they felt as if the decision had been taken unfairly. And the new rules provide for what they call a client-led disagreement process, which means that the consultant can give notice to the client that they disagree with the decision of an SDS. And that complaint can be given either in writing or verbally, but it must set out the reasons why the worker disagrees with the SDS. Now, once the client receives notice of the consultant's complaint, the client has 45 days within which to provide a response to that. And that 45 days starts to run from receipt of the notice. Now, the client has two options in that situation. It can either review and decide to uphold the existing SDS, in which case it must, within those 45 days, provide a written response to the consultant, setting out its reasons why the original SDS is upheld. Or alternatively, it can decide that the original SDS was wrong and will be withdrawn, and it can issue a new SDS, again, making sure that that SDS satisfies those three elements in order to be a valid SDS, i.e. in writing, giving reasons, and taken with reasonable care. Again, if the client fails to comply with the client-led disagreement process, for instance, by failing to comply with the 45-day time limit, or by failing to take reasonable care in reviewing the SDS, then responsibility to account for tax and national insurance will again stay with the client and won't pass down the chain. So it's really important for clients to make sure that they have adequate processes in place for dealing with any disagreements from consultants. So this is a really big ask of clients here, because they're being asked to apply what is a very complex and difficult test. And as I've just mentioned, HMRC has brought out a tool to help clients with that test, which is the Check Employment Status tool. Barry, could you tell us a little bit more about that?
I will. I'm going to skip over that slide because you really talked about it. But the Check Employment Status tool, it is an online tool, and it asks a series of questions, and it takes you through a process. And at the end, hopefully it gives you an answer that tells you whether the worker is inside or outside of IR35. It's not a perfect tool, but what HMRC have said is that if this is used properly and with reasonable care, so you don't try and massage it by going through several times to get the right answer, and the answers you give are actually truthful answers, then HMRC, when they come and ask the question, won't seek to look behind the answer you've got from the CESS tool. So it's very important that if you do use the CESS tool, that you keep a copy of your result and the answers, because you can print them all off and keep them in a nice pack, so that you can then say, well, these are the answers I gave, and this is the reason I gave those particular answers. If something changes, as Katie said, you'll need to redo the CESS test to make sure that the answer is the same, or if it has changed, you'll then need to issue a new SDS to the worker to make sure you're complying with your obligations. Now, what are the practical consequences of someone being inside IR35? Well, you need to include the worker on your payroll and deduct PAYE and national insurance contributions. It's also important that the worker completes new starter forms to determine what their correct tax coding is. Otherwise, you'll be deducting tax at a much higher rate than they may be willing, or they may want you to deduct it at. In addition, the fee payer becomes responsible for paying the apprenticeship levy, and the salary for the salary paid to the contractor or the PSC has to be taken into account for the apprenticeship levy, and you also have to pay employer national insurance contributions. and they're running currently at 13.8%. So there's there's a big increase in cost to having somebody inside IR35. In addition, at the end of each year, the fee payer will need to issue a P60 to the contractors inside IR35, and at the end of their employment, they'll have to be issued a P45 so that they have an appropriate tax code. So I wanted to try and represent this pictorially to give you some flavour of what it looks like in terms of cost. So as you can see in the column on the left-hand side, that's our current position as we sit here today. So you have a contractor, they undertake work, they'll invoice you for VAT if they're VAT registered, they'll pay corporation income tax, and then the contractor will get net pay at the end. Well, if we move across to 6th of April 2020, either if you are a small company employing a contractor, the situation remains the same, or if you are a medium or large end user and the contractor is outside IR35, then nothing very much changes. But then it becomes more complicated where you have people who are inside IR35. And the third column shows again VAT being paid, the apprenticeship levy, and the employer's national insurance contributions, and also an obligation then to pay PAYE tax, so income tax, and employee national insurance contributions. Now, the end user fee payer here, in order to try and minimize the cost for them, has reduced the amount of net pay being paid to the contractor. And you can well imagine having discussions with contractors about, well, yes, okay, we're not going to pay you any more, but we're going to take some of your net pay away. That's not going to go down very well. But if you leave the net pay at the level it is currently and pay your income tax, employee national insurance contributions, the employer national insurance contributions, the apprenticeship levy, and the VAT, then the costs begin to go up quite a lot, and it becomes a much more expensive exercise for the end client, whether that the end client be the fee payer or not. So there's a significant increase in cost to have people working inside IR35 as opposed to outside IR35, whether that be on a fee payer friendly basis or a neutral contractor friendly basis. Casey, you're going to deal with that.
Yeah, so this really just is an example just to illustrate the point I think that Barry has just made. So we have a contractor, Alex, who has his personal services company, B Limited, and he typically invoices the client £160,000. The end user client has issued an SDS to Alex, which says that he is inside IR35. So this means that the tax and national insurance payments on that £160,000 have to be deducted from those fees before they are paid to Alex's company, B Limited. So that deduction is £39,000. And this results in B Limited only being paid £121,000 rather than the £160,000 it would have been paid previously. So it's a substantial difference for contractors. And in addition, as Barry has already pointed out, it's increased cost to whoever ends up being the fee payer as well, because they will have to pay the 13.8% employee NICs and any apprenticeship levy due on those fees as well. And, you know, fee payers, who will typically be agencies, may look to recover those additional costs, either through putting that cost back up through the supply chain and charging the client more, or going in the other direction and looking to charge the contractor less. So
I think that's a very important point, Katie, that it is going to be a question of discussion between all of those in the supply chain as to how it's going to work and what people are going to be paid, because contractors certainly won't want to be paid less, and end users won't really want to pay very much more. So there's a huge tension there that needs to be resolved at some point.
And agencies are going to be right in the middle of it.
They're right in the middle.
Right in the middle of it.
Yeah. So what do we need to do now? Well, hopefully we've already identified contractors in the labour supply chain, and that's been an exercise that's been ongoing. But it's very important to make sure that you have identified all of the contractors in the supply chain. And it may well be that clients of yours are asking you, and certainly I've had clients of mine asking me about contractors that we engage with. And it's very important to review the terms and conditions, not only of the contract at the head of the supply chain, but all of the contracts throughout the entirety of the supply chain, to make sure that they are consistent and pointing in one direction. And that's going to be really difficult because everybody in the supply chain has a slightly different interest, and so lots of competing interests. But if you can make them all tie up, it's going to be much easier to argue on a status question, one particular argument, as opposed to having lots of different intersecting and overlapping areas. Do we have any? Sorry, Katie.
Sorry, Barry, I was going to say, no, I think that's a really important point, because if HMRC were to look at this and look at an SDS, they would take into account all of the contracts. So not just the contract between the consultant and, the PSC and the agency, but all of the contracts in that supply chain would be looked at.
Yeah. So are there any cases when we've looked at it that are clearly inside, or are they borderline? And is there any change that can be made to those situations to bring people up to the border and make it put into grey, or take them from one side of the border to the other? Can we change the way in which the work is being undertaken? It's also going to be important to decide how you're going to approach these matters. Which agencies are you going to work with? Are you going to assess each assignment on merit? You should be doing, which is going to create a lot more work for people to do and to manage. How is the work going to be undertaken? There are various models that one can possibly look at to try and bring people out, try and take things away from IR35, and that's quite a complicated area. Are you going to use a separate payroll? So you could have your employees on one payroll and your contractors who are inside IR35 on a separate payroll, just to make sure that you don't start giving them benefits and other things that they're not entitled to, because that will really push them inside IR35. You need to communicate with your contractors and the supply chain to make sure that everybody's understanding what's going on. What are your budgetary constraints? Can you afford to have contractors working for you if there's a significant increase in costs? Is it better to have people on a fixed term employment contract and then bring them to an end? And as Katie said earlier, we need to make sure that those who are engaging contractors and dealing with them understand the rules that are going to apply from the 6th of April 2021 to ensure that they don't inadvertently create a problem, either by not doing it with an SDS or by not understanding how to carry out an SDS with reasonable care. Katie, have you got anything else you want to add?
I think it's just to make the point that, I know many of the people listening to this, obviously this is a postponement of the new rules. And so many of you, I'm sure, will have already perhaps even undertaken SDSs already and be quite some way in your preparations. And I think it's just to make the point, particularly around the SDS, that, a lot may well have changed. So you might have done SDSs before, you may have already audited your supply chain. But unfortunately, over the passage of time, things may well have changed. And I think it's really important that no matter how well prepared you were last year, I think you do need to thoroughly revisit what you have done and look and revisit and do anew SDSs, and re-audit your supply chain as well.
Now, I'm conscious that we are at 3 o'clock, but Katie and I are very happy to stay on for a little longer and answer some questions. Kerry, do we have any questions?
Yes, we do have some. Thank you for that. That was really informative. We've got some good feedback here. So we've got one question from Angela Morris. We often find a consultant meets half of the test and fails the other half. Have you got any advice on which criteria carries the most weight?
I think as the cases that we were talking about illustrate, no one criterion carries more weight than the other. And it is very much a question of looking at all of the criteria and then stepping back and trying to weigh up what it looks like and what it feels like. So, when we looked at the Canal Street Productions case, I remember reading that this time last year and thinking, well, she's definitely inside, and getting to the end and going, oh, well, how did that happen? And it was all the other factors that took it outside, as opposed to the core factors you thought would take it inside. So it is really difficult, and that's why, as the HMRC guidance says, it may be necessary to take some professional advice around some of the factors, particularly if you're coming up with a balanced set.
I think that's right, and I think that this is a very heavily litigated area, particularly now. And so the case law is constantly evolving, and so you really do need to have your finger on the button with it. So particularly with those cases where it is unclear and it is a bit borderline, it is worth, perhaps, if you're really unsure, seeking advice, just to perhaps make sure that the most up-to-date case law is being applied, because there may be something which has come out that may assist with that, but it's not easy at all.
Kerry.
Yeah, so a lot of people are dropping off now, so I'll do one more question. Let's have a look. Is there a time limit for when the contractors themselves can bring a disagreement with determination grievance?
They have to bring that within 45 days of being given the SDS. I think that's the question you're asking.
No, I think that was the question was whether is there a time limit for the consultant to make a complaint? So the 45 days is for the client to respond to that complaint. Oh, so the consultant has to bring that complaint. Can bring that complaint at any point during the after it receives the SDS and during the engagement. But once the engagement has come to an end, then the consultant can no longer bring a complaint.
So we're going to leave it there. Thank you for those who carried on listening, and to those who unfortunately had to drop off. Kerry will be posting a copy of the video onto YouTube, and we'll be sending a link to that. And we will be working through the questions we've not had an opportunity to answer today over the course of the next few days, and sending that out to everyone in the early part of next week. Thank you very much to everyone for listening. Bye-bye.
Thank you very much, everyone. Bye-bye.